Testing, testing. Okay, so we're on the record in the Public Service Commission's rulemaking 85 on energy storage, and Mr. Burkowski.
Okay, well, good morning, Chair Hoover and Commissioners. Again, John Burkowski, leader of the Maryland Energy Storage Work Group. And with me today on my right are Mike Dean, Assistant Staff Counsel, and on my left is Katie Houck, who's currently a fellow working in the Office of the Commission on various initiatives with the advisors and OGC. And Katie's going to be assisting me today with any edits to the regulations that are made by the Commission today. So as background, just a little bit of background, during its 2023 session, the Maryland General Assembly enacted House Bill 910 that amended the Public Utilities article to establish the Maryland Energy Storage Program. And to that end, the Commission issued Order Number 90823 that established Case Number 9715 and launched the Maryland Energy Storage Program Work Group last October in 2023. Actually, 2 Octobers ago, so October 2023. To meet the Maryland Energy Storage Program targets, it will likely take a combination of different programs with both utility-owned and third-party ownership and operating models, and also programs that address both the front-of-the-meter and behind-the-meter energy storage devices, and also programs that may include energy storage procurements, deployment incentives, and grid services mechanisms. Therefore, although the types of different potential energy storage programs are very diverse, this RM85 regulation proposal is written to apply to any energy storage program. In addition, this regulation proposal is written in a way that will allow this rulemaking to proceed independently from the Commission's Maryland Energy Storage Procurement proceedings that were recently announced by the Commission to begin on March 25th. Therefore, taken together, both the March procurement proceeding and today's RM85 rulemaking are prerequisites for the launch of the Maryland Energy Storage Program by July 1st of 2025. Now, in our report, our work group report filed October 1st, 2024, the work group requested that the Commission initiate a rulemaking session, and then subsequently, once we viewed the initial filings, the work group recommended and the Commission approved canceling its initial rulemaking schedule scheduled for December, and this allowed the work group some time to eliminate or reduce the number of non-consensus issues. And I'm happy to report that our efforts were successful in that the number of non-consensus issues appear to have been significantly reduced. So I'd like to thank our work group members, including our consultants, the Energy Policy Design Institute, for their collaboration on these proposed regulations. Now, there were 6 filings in the RM85 docket submitted in response to the Commission's notice of rulemaking session and comment period, and these filings were by the Office of People's Counsel, the Maryland Exelon Joint Utilities, meaning combined BGE, PHI, and 9 Energy, Advanced Energy United, PowerFlex, and Rev Renewables. And we may have some other stakeholders here today also. Some of whom may have filed comments in the first round of comments submitted in RM85. Now today I propose to sequentially cover the regulations. We have 12 regulations in this new chapter that we're establishing, and I would like to highlight the non-consensus issues while also providing stakeholders an opportunity to comment on their proposed edits as we go through each regulation. So after I cover all the regulations sequentially, then I would recommend that maybe the chair would make a last call for any remaining stakeholder comments that have not been addressed before taking up a motion to approve the regulations So unless there are any questions, I'll get started with Regulation 1.
Yeah, thank you, Mr. Prokowski, and nice job in achieving consensus. I guess my only question is in terms of pricing the value of storage, when is that going to be addressed?
I think that these regulations are agnostic to the pricing, meaning we're trying to set up something that could be satisfied for any program, but the specific proposals that are made in the proceeding that the commission will hear in late March should address some of those pricing issues.
Okay, great, thank you.
Yeah, and there were, just to add on to that, there were comments by stakeholders, even in the latest round of RM85 comments, they're probably more appropriate to address in those proceedings than in a rulemaking. But, you know, we'll leave it to the stakeholders to make their own comments as we go along. Okay, any further questions? Okay, we'll go to Regulation 1. This is just the applicability section, and I did not see any comments filed in this section, so I would just ask if there are any stakeholders that have any thing that they want to add in this section or this particular regulation.
Don't see any takers, so.
Okay, so we'll go on to the next section, which is the definitions, and I keep saying section, it should be regulation. So in the definitions regulation, we did have one proposal by OPC to change the definition of cost effective. So I think at this point it might be appropriate to invite OPC to talk about their change.
Good morning, Chair Hoover, Commissioners. Mark Shebas for Office of People's Counsel. We made this recommendation consistent with comments we made on the first set of the first draft of the proposed regulations and these as well. We appreciate the work group leader inserting a definition of cost effective. In the initial draft, there was not a definition. The background here is that the statute, 7216.1, uses the term cost effective or cost effectively multiple times. Don't have it in front of me right now, but it's 5 or 6 times. It was clear, at least it was OPC's understanding, and I believe it was the understanding of the legislators and other stakeholders as well, that cost effective in that statute means what it has typically been understood to mean in Empower and other proceedings of the Commission, which is that the benefits must exceed the costs. The definition became an issue in the work group because the work group report that was filed on October 1st proposed a possible different approach to cost effectiveness, and that was so-called cost efficiency approach. And Mr. Borkowski can weigh in if I'm mischaracterizing this, but I believe that the idea behind cost efficiency is that it's not necessary for the benefits to exceed the costs. The alternative that's selected just has to be the lowest cost of various alternatives pursuant to some kind of competitive process, with the result that you could potentially have any number of projects that none of which are cost effective per benefit cost analysis, but one of them would have to be chosen pursuant to the cost efficiency approach. OPC is concerned about that just because of the current uncertainty regarding what the cost of these projects will be. I think, you know, one of the big reasons why we're here at all today, why the General Assembly established these goals, and why we're talking about utility procurements and about deployment incentives, is that in the current markets, storage isn't doing very well in the PJM wholesale markets right now. There are a lot of reasons for that. I believe in the most recent auction, only 14 megawatts of storage cleared across PJM. I don't know how many of those megawatts were in Maryland, but you know, and again, the reasons for this are complex. I think you can boil it down by saying that the PJM wholesale rules are not favorable to storage right now, and there are ongoing disputes about you know, the design of the capacity market that hopefully would make it easier for storage to participate and receive revenues through the PJM markets. Right now, though, standalone storage is not doing very well in the market. That makes it necessary for the state to provide incentives and subsidies for storage for it to pencil out, as they say, and for these projects to get built. And we appreciate that and are not opposing the program, per se, not opposing the notion of utility customer incentives per se, although we believe this is one of many programs where the funding could come from other sources than ratepayers. But given that under the current proposal, and I think the idea is that most, if not all, of the funding for these programs will come from ratepayers, that cost effectiveness protection becomes extremely important. And we don't think there, again, if there was an intention by the legislature for cost effective to mean something than it ordinarily means, and that what's always been understood by the Commission to mean, I believe the General Assembly would have defined it as such. But given the dispute within the work group that's created uncertainty about what that term will mean with application to this project, we think it's appropriate for cost effective to be defined, not per some extraordinary definition, but just by virtue of the way it's commonly understood and the way that we believe the Commission has always interpreted the term. So that's the background for our proposal to delete the phrase "while considering other factors" that's shown on the screen here. And I'm happy to take any questions. Thank you.
Actually, Commissioner Barvet, and then
Yeah, so let's dig into that a little bit. So basically, your position is that the legislature made a decision to, by default, to go by default to a traditional strict benefit cost analysis rather than having the commission do trade-offs between cost and other climate change benefits.
That's correct, Commissioner Barber. We first have to look at the statutory text, which again uses the term cost effective without any sort of definition, and then look at the legislative history. We couldn't find anything suggesting that the term cost effective should mean something other than that the benefits should exceed the costs.
Okay, and are there, I guess, offshore wind is a specific example where the legislature said we can look more broadly, and so you're basically saying that because the legislature didn't go in that direction, we should presume that the legislature wants us to stick to a more traditional benefit cost.
That's correct, Commissioner. We see this as a matter first and foremost of statutory interpretation. There are policy arguments that it would be better for the Commission to consider, basically to apply a definition like this in determining whether to approve storage initiatives and storage projects. But given the way the statute is written now, we don't think the Commission has that option.
Okay, thank you, Mr. Chairman.
Mr. Richard.
Yeah, just continue on. I was interested in trying to understand the difference between what is being proposed by the work group and the OPC. So, if I'm understanding, it's basically OPC's position that it has to be a cost benefit of 1 or greater at that point.
That's correct.
I guess where I get a little concerned is how do we know generally what the denominator is going to be. It's just trying to figure out what that numerator, the benefits are, and how do we get to that? Because that's where I think we're having maybe the issue of maybe the language you're trying to suggest versus what the work group, because there's a lot there, and you mentioned something about our experience in Maryland. But just some of the research I've done and presentations I've heard, California, their California Commission does consider a lot of their projects, their energy storage projects, to be cost beneficial. So again, I want to make sure we're careful here what we do with the language, so we don't just jettison projects. So maybe you can help me a little bit. How do we get to the right numerator, I guess?
Yeah, I think, Commissioner Richard, that's a tricky question, and I think that sort of informed this whole debate within the working group. I think there was a sense that that storage, if it were built out, would ultimately have benefits that can't currently be quantified through a benefit cost analysis. And that was the grounds for approaching this from a cost efficiency perspective rather than a cost effectiveness perspective.
Okay.
It's difficult to, I think, and I think digging a little bit deeper into that, the promise of storage is that if you get a lot of storage online, it will enable a lot more renewables than are currently able to come online. It will help make them economical in a way that they're not now. And we do think that's possible. We don't think that's an inevitable conclusion, but we certainly think that it is a promise of storage. And I think the difficulty is how do you quantify those potential benefits, because I think they are right now potential benefits, and we don't know what, how much those benefits will be or when they will appear, which are, big factors in any benefit cost analysis. So it's a tricky question, but we think, again, it's first and foremost a question of statutory interpretation in this context. Mm-hmm. You're raising concerns that I think are appropriate for debate within the General Assembly with respect to whether this statute should be written as it is. But right now, we don't think there are grounds for taking an alternative approach given the language of the statute.
Okay. Well, no, and I appreciate that, and I think we do need to get this right, but I just want to make sure this doesn't become like not just a speed bump, but a brick wall if we put this definition such that we are overly, or we don't take into consideration the important factors that may go into that numerator, and you used it like PJM. I mean, right now, with we just learned this morning that the in immediate needs projects now have gone from about 700 to 1.5 billion dollars for just addressing the RMR at Brandon Shores. And the point there is, there could be. I mean, how much storage could we build for $1.5 billion? And you think also 60 to 70% of that cost is going to go to just to the Baltimore zone. So I just want to make sure that we are considering all the benefits of these projects, these potential energy storage projects, to obviating the needs of these out of control, PJM projects that we're looking at. So again, I don't want to spend too much time on this, but I just want to make sure that we're getting this definition right, so that we are valuing these projects, and we're taking into consideration, and that's why I kind of like the factors word to consider all the potential benefits of these projects. So.
Yeah. No, that's fair, Commissioner Richard. One other thought on the sort of benefit question. I mean, coming back to the capacity market, I think the other thing that's been much discussed is that storage could help bring down some of these very high capacity costs that we saw in the last auction, and I think that most people expect we'll see in at least the next couple auction before we get new generation resources in there to change the market dynamic. But again, I think one of the extent to which this new storage can really benefit capacity market prices turns on how much storage can participate in the capacity markets right now. Mm-hmm. OPC filed a protest, I think it was last week or the week before.
And I don't want to get too far afield here, and I agree. But in some cases, it could be just an alternative to a transmission line. Mm. And in this, if we're suddenly looking at a $1.5 billion solution to take care of the deactivation of Brandon Shores, which is what 1.2 gigawatt, and we have a program here that is looking to put 3 gigawatts of storage online. I mean, that seems like if we could potentially do some of that for less than $1.5 billion. It just I just want to make sure you're getting this right, so we don't create an inappropriate speed bump for this program.
And Commissioner Richard, one further thought in that I think that use case that you're talking about there with respect to PJM transmission planning and transmission projects that are built pursuant to that process, there's a discussion ongoing within PJM about storage as a transmission asset, mm-hmm. or SATA, which you're aware of. I think that if it moves forward would be the most viable alternative to to ensure that storage can be considered as an alternative to those bulk transmission projects.
Yeah, I agree. We had the recent resource adequacy hearing, and I think we're trying to figure out what can we do in Maryland, as we wait for PJM to come up with acceptable solutions, so we can maybe find better solutions. And I think, again, getting this right with the storage program is I think, an important step. So thank you. Thank you, Mr. Chair.
Commissioner Barbie, you had a follow-up?
Yeah, so let me continue on the vein that I started on. As you know, the CSNA actually has the legislature stating that a goal of the state of Maryland is decarbonization and fighting global climate change. And while that's not a specific statement on benefit cost analyses, it is one of the things that we have to take into account. So what would you say to the counter argument that while the legislature may have left a more traditional benefit cost analysis language in the law that they passed, they still have established a mandate for us to take into account decarbonization and climate impacts. Is that enough of a public mandate for us to not take the position that you're requesting?
Commissioner Barber, it's a good question. I think there is a tension between the state's ambitious greenhouse gas reduction goals and any sort of limitation on the cost of funding those goals. And the state's having a big debate. The MDE's climate action plan issued at the end of 2023 said we need a lot of money, $1 billion per year for the next, 10 years or so to meet the goals. But I think the way to square that difference is again by just looking at the statutory language. If the General Assembly believed that there should be sort of unlimited potential costs with respect to this program, it would have written the statute differently. I think there are other potential ways to come up with funding sources, but I think our interpretation of 7216.1 is that the General Assembly recognized that there are limits to the extent to which you can fund programs through utility bills. And I think the increases that we've seen lately, the additional increases we're going to see starting in summer when the most recent capacity auction prices hit bills, that is really serves to justify the language that the legislature did include.
I'll say as an aside, Mr. Chairman, that in talking to my former colleagues, they all regard battery storage as a key breakout technology, and the lack of it as being a major hurdle, a major choke point for one of the major choke points for an expansion of renewable energy. But I can see both sides of the argument, so I don't have an opinion as this moment. Thank you very much, and thank you, Mr. Chairman.
Commissioner Sussman.
Yep. So the concern I have in following up from my colleagues' questions is that I see battery storage differently than other technologies because it has the potential for multiple benefits, and that's actually why I asked Mr. Borkowski earlier about pricing, because I think that's going to be a sticking point. How do you price? And you're going to probably need to price it differently depending on what the storage is going to be used for. And so I worry that we're getting caught up in semantics. I mean, benefits, how do you define benefits? It's kind of like, how do you define life cycle costs? I mean, how far do you take the benefit calculations to the extent that you can use storage to avoid having to build out more generation, more transmission or more distribution? That's going to be a savings, and that could end up being huge savings when you compare it to the cost of having to build out other wires. But what I like about having factors in here is to actually highlight the fact that storage is different, and we need to think about storage differently. And maybe we can't sort of use the same old benefit cost calculations because it's different and because it can have huge benefits that can see huge beneficial impacts in terms of the rates that customers pay. And I'm very concerned about rates. And so I would like to keep the flexibility that factors can play in the definition to signal to the market that we're interested in storage for a variety of different reasons. And to speak to the point about the fact that we don't have enough storage, I think it may just be that we haven't priced it properly. And it may not be that we get storage through the capacity market. We may have to do it differently. But Mr. Chairman, I like the idea of including the consideration of other factors because we need to highlight the fact that storage is different.
Yeah. And Commissioner Sutphin, I appreciate it. I think we share the same goal. Again, OPC doesn't disagree that storage can have enormous benefits, but we're concerned that to the extent those benefits are too speculative now, we could be putting ratepayers on the hook for a lot of
Well,
money.
then you're going to have to trust the commission I mean, I think that, the fact that we're putting this language in doesn't mean that the storage companies can go crazy. I mean, all this is doing is saying that we're broadening the scope of what we look at, but ultimately when they come to us, we're going to be looking at what the project is, and we're going to be making decisions about whether it's okay to go forward.
Thank you, Commissioner Sutphin.
Okay.
One other just further thought is like on the benefits, we also agree that storage can have multiple benefits depending on how it's used. But one complication there, I think, that's relevant to this question of how to define cost effective is that, using storage in one beneficial way could preclude its being used in another way. If storage is qualifying as a capacity resource and is participating in those auctions, it's got to be available when called, and that might limit the extent to which it can be used as a distribution resource to avoid distribution costs.
And that's what we will consider when the project is before us. I think really what this does is it just sort of says that we are open to considering all kinds of factors when we're dealing with storage.
So, sort of joining the choir here, I think my thought is that there's a lot of interest in the General Assembly in using storage as one of the ways to get to the desire to have more in-state energy facilities. And in fact, tomorrow, I'm testifying on a bill that's pretty aggressive with deployment and timetables for storage projects. So I guess I'm of the similar opinion that's been shared up here that, I want the flexibility for us to be able to approve these projects. And, and obviously we're going to use common sense and I know there were problems with the initial storage program back when it was a pilot because of the war in Ukraine and then COVID and all the other stuff. But I think, there's a view on the part of the state's leadership that, storage is one of the key factors in sort of dealing with the energy issues that we have in the state. And I'm concerned about putting the developers in sort of a financial straitjacket, if we have the cost effectiveness be too tight. And so I want the ability to sort of use common sense and use our judgment, which is what we get paid to do when we're approving these things so that they don't go haywire. But on the other hand, I want the ability for us to consider other things other than the strict arithmetic cost effectiveness. So.
Understood, Chair Hoover. I think, OPC just has a different take on this, and we respect the Commission's position. The last thing I think I would say is just that if the Commission, if the General Assembly believes that the cost should be more expansive and that the Commission should consider factors other than cost effectiveness, we're in the middle of a legislative session right now, and the General Assembly has every ability to amend 7216.1 to make that change, and it hasn't done that yet.
I understand. So, now let me, was OPC the only one that made this suggestion about?
Yes, sir.
Okay. All right. So I think I want to keep the language as developed in the work group report and not make this change, so.
Okay,
Anyone disagree? Okay, all right.
Thank you.
Sure.
okay, thank you. Okay, I'll just ask if there were no other
No,
written edits to this particular regulation 02, but I'll ask at this point if there are any other stakeholder edits proposed for this regulation.
so speak now or move on. Looks like we're moving on, so.
Okay, we're going to move on to Regulation 3, which is about Maryland Energy Storage Program Administration. And there was a recommendation by Advanced Energy United that Katie will put up on the screen. It's at the bottom of the, there you go. You can move that up. No, just go down a little bit. You had it.
Yeah, I think it's on page 8, top of page 8.
B5.
Splits it though. Just keep going.
Yeah, that's
yeah,
fine, that's
yeah,
fine.
Yeah, keep, just,
There you
now we got it, yeah, right in the yellow stuff, okay. No, we're good.
Keep going. Okay, we got it. Okay, so this particular regulation, and this is Regulation 03, Section B, Counting for Enrollment and Registration. Advanced Energy United recommended that we simply clarify the last sentence, which is struck through: a pre-existing energy storage device cannot be enrolled in an initiative, and be more specific that cannot be enrolled in an initiative offering a deployment incentive mechanism or a procurement mechanism. And I don't know if Advanced Energy United is here today to talk to this, but from a work group perspective, this did not come up. This clarification did not come up, but I have to say I don't think there's any harm in making the edit from my perspective.
I guess the question is, are there other initiatives other than these two identified?
But yeah, I should have elaborated a little bit more on their rationale. We eventually want to get to offering grid services in Maryland and appropriately recognize, the value of energy storage. We don't have retail tariffs at the present time, and as Mark from OPC mentioned, even PJM doesn't have markets that fully recognize the value of energy storage at this time. But we did sort of indicate it that if you're pre-existing, you don't need an incentive. But if you are pre-existing, you should be able to participate in one of these grid services when it's available. So that was the impetus behind the change, and I think that I think that I think the clarification is useful.
Yeah, and I don't know what an initiative is because it could be anything, and so I agree that defining it by including just those two provisions also gives you flexibility to the extent that you have identified another initiative that you would like them to participate in.
Right. Okay, so
Anybody else? No.
I'm trying to get the what's happening here correct in my head. So if there's a pre-existing storage facility, and and then there's an opportunity later on for it to be part of like a virtual power plant,
Right.
is this allowing that to happen?
Yes.
It is. Great. That's all I need to know.
Yeah, we don't have those tariffs set up yet, but once those tariffs are set up, pre-existing energy storage devices should be able to participate in those tariffs.
Okay, good. I just want to make sure the flexibility was there. Thank you.
Okay, I guess we can go ahead and incorporate it.
Okay, so I did not have any other edits in this particular regulation 03, so if we go to, and I'll make the last call, I guess. Not seeing any, we'll move to regulation 4. Okay, we had a change in regulation 4, and I think there's also similar changes in regulation 06. But OPC wanted to strike the if applicable terminology in a couple of different areas. So I guess I would invite OPC to provide their rationale, if the chair agrees.
Sure, that's fine. Sure.
Thank you, Mr. Prokowski. Thank you, Chair Hoover. This is mostly a matter of clarification. I mean, our understanding of why the phrase "if applicable" is included here is that there is the potential to seek exemptions under the exemptions part of the regulation. And that if an exemption was obtained, then this regulation would not apply. But we don't think that's a good reason to, I mean, Mr. Borkowski could clarify if that's the correct reading of this, but if it is, we don't think this language is helpful because it's basically just unnecessary. If an exemption, the regulation applies, and if an exemption is obtained pursuant to the exemption regulation, then the regulated entity is exempt from these particular requirements. But we think having the phrase in there injects a kind of ambiguity about what applies and what doesn't, and we think it would be clear if that phrase were struck.
Can I just quick question? There's another if applicable for regulation .9. Would you be striking that as well, or leaving that if applicable in your recommendation?
This gets a little tricky because there was, I think, one place where we believed it was appropriate.
Okay, so regulation .9 of this chapter, if applicable, is okay. It's just regulation 10 of this chapter you would want to strike the if applicable.
Well, I'm sorry, Commissioner Richard. I'm looking at our comments now, and we actually pointed to it was regulation 09 that we have pointed to in our comments, saying that it applies to all front-of-the-meter energy storage devices that are enrolled in the program unless the device is exempted from the regulations pursuant to the exemption regulation, which is .07. So we do think that regulation .09 has the same issue.
So both.
Okay.
Correct.
Okay.
Okay, so, and if you could introduce yourself, spell your name for the court reporter, and then go ahead.
Absolutely. Good morning, Commissioners and Chair. My name is Andrea Harper. I'm from my spelling is ANDREAHARPER. I'm from Pepco Holdings and on behalf of the Joint Exelon Utilities. We think that it's important to have that if applicable in there. There is in 7G, there is an express exemption for storage devices that have gone through an actual CPCN. And when we read this, and it excludes from duplicative requirements in this regulation in .08, .09, .10, and .11. And we think that that's really important because if you don't have if applicable here, then those storage devices that went through the CPCN process would also have to go through this process even if they've already had duplicative examination in the CPCN process. So we read that as allowing storage devices that have gone through the CPCN not to have to also go through those provisions here.
Oh,
Chair Hoover, if I could weigh in, I don't think we disagree with that interpretation, but if that is the intended meaning, we think that it would be better to maybe phrase this as except to the extent exempted under 20.50.14.07G, to specifically refer to the regulation rather than having broad general language.
We would be fine with that, as long as the exemption for CPCN storage that has gone through the CPCN process is
And
obvious.
would that apply to the other place where you wanted to strike the if applicable?
This also comes up in .06.
Okay, but if with that language, that would cure the issue in play? So it would, so you'd sort of have specific reference to the exemption language in both places as opposed to just if applicable. So you'd strike if applicable. So I see that in '06 as well.
Yeah, I'm sorry, Commissioner, I'm just taking a look here.
Okay. And Pepco would be okay with just the specific reference to what the issue in play is.
Yes, Your Honor.
Okay.
We would.
Okay.
Yeah.
so-
I'm sorry, we think the same substitution of language could be made in this provision as well.
Okay, so can you give to Mr. Perkowski what the specific language you'd like?
Yeah, I was gonna say, yeah, let's see if we can
You're gonna-
get the words there.
Yeah, well, my just off-the-cuff recommendation, and Ms. Harper should weigh in, is replacing the phrase "if applicable" with "except to the extent exempted under 20.50.14.07G."
And the joint Exelon utilities would be fine with that, Your Honors.
And Mr. Chairman, that, just to be clear, that's the part of the PUA that refers to CPCNs? Or what?
Yes.
Okay, thank you.
Oh, okay, so just to be clear, it's going to be put into 4 different places
Right.
in '06 and '04. That's,
2050. Geez, I can't even read that.
so you'll strike if applicable in the 2 places in '04 and then the 2 places in '06 and put that language in.
We should do that now. That's good. Just copy.
Well, let me ask you this. Does this fit in this general rule about non-substantive changes? If in fact, we like miss something?
I thought this was just clarifying.
Yeah.
Okay, all right.
I think in the end, when we rewrite
Right.
this,
yeah,
it'll
yeah,
just
yeah. I
refer
understand.
to
Right. Yeah.
regulation
Sure.
.07G instead
Yeah,
of
I just
the
thought-
whole
Yeah.
2050.
So just in case we miss one or whatever, but I think we're,
Yeah.
you know, conceptually, we're fine with this
Yeah.
amended language, so we'll strike the if applicable, substitute this new language, and make sure it goes into the various provisions. Okay, all right, okay, all right,
Thank you.
Andrew says we're okay.
all right, sounds good.
Okay, we're going to revisit this very briefly in
Mm-hmm.
'06. Why don't we do this now so that we don't have to come back to it? So when you're done with '04.
Oh, so it's in H, right?
Yes, it's in.
Oh,
H.
HNI, yeah, right, yeah, okay, so, okay. No, I think we're fine doing that, so. Same.
Okay, so just to be clear, Mr. Shebus, the same issues in play in '06I, the if applicable,
HNI.
H and I.
Right, yeah.
But just to be clear that I has the same infirmity that will be addressed through this change in language.
Commissioner Sussman, I think that's correct.
Okay.
It's a little challenging to toggle back and forth.
Yeah,
between
no,
all
I
these
understand,
different provisions,
so,
But
so.
But yeah, I think the the regulation mentioned there on the screen, .07G, has pretty clear exemption language, and as long as these, these references are to that specific language, so that it's clear that there's not something else that's being considered, I think OPC is fine with that.
Okay,
Okay.
thank you.
All right.
Yeah. Okay, so we're back at '04. I had nothing else in '04 unless another stakeholder has a comment. So if we're done with '04, we'll go on to '05. Under '05A, we had a recommendation from Advanced Energy United. And again, it's a clarification similar to the one that they made earlier, ensuring that we allow pre-existing energy storage devices to participate in these programs. So they recommended some wording, except for pre-existing energy storage devices seeking to enroll in a grid services mechanism. Et cetera. And I guess the point is that, they should still be able to enroll in a program. I have no objection to this additional language unless another stakeholder does.
I don't see any, so I think we're good. So.
Okay, so we've accepted the Advanced Energy United recommendation for A. Any other items in Regulation 05? Hearing none, we'll go into 06, keeping in mind that Regulation 6, OPC made some
Right.
recommendations which we've already taken care of. So are there any other changes recommended to .06 at this time?
All right.
Okay, seeing none, we'll move on to '07. And we have in '07 a recommendation from the Maryland Joint Exelon Utilities with Section H of Regulation 7. One of the items we try to get consensus on in the work group, and we do have some non-consensus about the some of the developers have expressed that it will be a burden for them to participate, stakeholder engagement and participation in PPRP review requirements would be burdensome for some developers because they're dealing with small front-of-the-meter energy storage devices, which would still have to go through that process. The problem we had during the work group is identifying all the use cases where we might want to codify. So we left in a blanket exemption provision to say that basically, a developer could make a request for a blanket exemption for devices of certain characteristics, and we could do that. In general, we don't want to make blanket exceptions, but we don't know all the use cases at this point. So, I think if we're going to put in blanket exemptions, and later on when we revise these regulations as we fine tune, we would codify some of these blanket exceptions and get rid of them. But we kind of put this in here to deal with situations and use cases that we're not aware of at this point. But we did have opposition to this from the Maryland Joint Exelon Utilities, and we also, in other sections dealing with stakeholder engagement in the PPRP review process, we had some alternative recommendations for maybe codifying their particular use cases that they would like to have in there instead of relying on this blanket exception. So I guess I would, with the chair's approval, and invite MJEU, Maryland Joint Exelon Utilities, to provide their rationale.
Could I just, Mr. Chair, ask a couple of questions? I'm just trying to understand what we're talking about here. So this would be, I guess, the proposal for projects less than 20 megawatts. Is that correct? Is that what the blanket exception is being requested for?
That's what Nine Dot Energy and I think PowerFlex also recommended that in a later, regulation section.
Okay, can you give me a sense of how big is that? What kind of space does that take up? I'm just trying to conceptualize what we're talking about when we're talking about these types of structures.
Yeah, well, typically, the rule of thumb that I've been using and was suggested by one of the developers in our safety sub-team is that 20 megawatt hours may take up about two 40-foot wide trailers, 40-foot long
40-foot.
trailers.
So each one is 10.
Yes. So if you're not dealing with large sizes when you're getting less than 1 megawatt hour or so.
Okay.
And,
And this would be applied to non-utilities, right? This is, okay, so these are companies that are not cost of service. This comes out of their bottom line,
Right, right.
essentially. So what kind of, generally in Maryland, local requirements, what kind of local zoning and local permits do these kind of projects need to go through?
well, right now, we go through just standard permitting. There is an effort underway. There's a battery commission that's run by the state fire marshal as a result of legislation that was passed last year, is trying to come up with specific requirements for lithium-ion battery systems, including grid scale. And at some point, we're probably going to have to sync up with them, but I think it's more likely that we're going to influence them because we have reps, PPRP has reps on that commission. But to my knowledge, the counties have not addressed this other than their standard requirements.
So this specifically, I mean, I know if my neighbor wants to put up a fence, like all the neighbors around, have to be notified, and I'm just trying to understand if what may already be covered by any kind of construction in a jurisdiction generally, and what would we be adding by having a requirement to have a utility like I guess public disclosure process?
Well, the public disclosure process was advocated by several groups, particularly the group that was involved in opposing the Pepco Livingston Road
Right.
project. And that was a very small project. I think it was and Pepco representatives can correct me if I'm wrong, but I think it was about a 1 megawatt hour project
Yeah.
or whatever.
Right.
Maybe a half a megawatt capacity, 1 megawatt hour.
Okay.
So to some extent, that heavily influenced the stakeholder engagement requirements, but we also recognize it was probably burdensome to do that, which is why we put the waiver provisions in, because we felt like we can't identify all the use cases now that might require, a public engagement process. So, at least if a developer was filing a exemption request, there would be public notice that that exemption request is out there, and people could oppose it if they chose, and if not, it's likely that for a lot of these smaller projects, we would recommend, or staff would recommend, probably approving the exemption. But we did say that larger projects to seek an exemption, like above 20 megawatt hours, we wanted PPRP to weigh in on those projects. So it's not ideal. I think it's a starting point, to try to at least provide some transparency to allow stakeholders, to weigh in, if they would oppose an exemption, because we would figure that a lot of these smaller projects would request exemptions. And then that's also why we created the blanket exemption, because, we could, bundle a bunch of projects under, with certain characteristics under one blanket exemption, and that's why we were trying to basically propose that. So it was a sort of a way to try to at least provide some transparency and afford the opportunity for input. But we didn't want it to be burdensome either. And we thought that in the work group, when we talked about it in the safety and environmental sub-team that we had, we thought that we would just try to deal with this through waiver provisions and instead of trying to, figure out at this point, how to codify it. I know we looked at other states, and there aren't a lot of other states that have regulations around this. I know we looked at Indiana, and they have sort of like a, 1 megawatt hour type of requirement in Indiana, but we were having trouble even with thresholds, because of the fact that we're just starting with these type of programs, and I think we just recognized that we would learn over time, and maybe we could fine-tune the regs to be more specific about the types of things that needed to go through the stakeholder engagement process.
Okay, yeah, I just wanted to kind of level set on a couple things where the work group is coming from, but again, for these non-cost of service companies, I'm just trying to figure out how we find that balance between not overly burdensome, but what might already be in place. It's hard in Prince George's County to really build anything without having some kind of a very public process. So I would assume that something like this would fall into that same category. So thank you.
So, Mr. Burkowski, did you consider putting limits on the number of storage projects that could be bundled? So, I mean, my concern is the potential gaming. So you could have 100 of these, and then ask for them to be bundled with a blanket exemption. I mean, presumably we would say no, that's gaming. I mean, I can understand 2 or perhaps 3 storage devices being bundled, but there wasn't a consideration of, okay. And then if this provision were not to be here, we could still bundle is the concern that if the provision's not here, that the opportunity for bundling wouldn't be available?
No, I think that anybody can make a petition to the commission and they can choose to bundle,
Right.
their requests. I think that we were trying as a work group to provide, some clarity that this even exists, because you got to remember, we have a number of developers that are involved in our work group. Many are out of state,
Right.
and they may not be familiar, but at least if it's codified in regulation.
Right, so they would see this and they would see that there's an opportunity for them to make money by bundling rather than have these sort of one-off projects. So this is kind of a signal to them that there is an opportunity for bringing on site several of these. Although, how do you sort of divvy them up? I mean, do they come to us and say, well, they're all on site, but there are 3 different storage devices because they're in different trailers?
Well, if we can go to the regulation section right below here for I, you'll see one of these opportunities to bundle right now. So to answer your question, because one of the bundling, anything less than 20 megawatt hours, and the following conditions were met. So this might be presumably in a request to the commission to, provide some sort of blanket exemption for any device that meets this criteria.
Right, but the concern I have for that, and you've raised this, is that these are sort of use cases, and you don't really, since we're sort of early in the process, defining what is permissible and what's not. It may be premature at this point. But anyway.
Yeah, we just haven't done enough
Right.
research and don't have enough experience, and I definitely empathize with the concerns of the developers, but we tried to at least provide an avenue to more efficiently deal with these things while also providing the opportunity for stakeholder engagement through the application for an exemption.
Well, but Mr. Prokowski, we could also do that in a decision before us. So it doesn't necessarily have to be through rulemaking, and that would give us the flexibility that the first or second or third of these projects comes before us, and we can lay out in an order once we have some additional experience.
Right.
And Nine Dot and PowerFlex are not here today, I guess, to speak on behalf of this. That's unfortunate. Okay. Yeah, I would be sympathetic.
I just really want to hear from Pepco.
Yeah, I would too,
Very
yeah.
curious
All right,
to know why
okay,
they oppose this. Okay.
Thank you very much. And we don't oppose waivers. There may be very well many situations where a waiver, a single waiver, is applicable. What we are opposing is the blanket waiver, and it's because of the importance of stakeholder engagement, as we've seen in our business, and the fact that, this may be an environmental justice issue. There are many residential communities that over time have been forced to be next to a commercial zone, right? And you could put one of these small, but you just heard that the small is 2 tractor-trailer size batteries right up abutting the residential property of someone. It could be just greater than 100 feet, but that person has the right to understand what's being done and to comment on it. And so all we're saying is providing that stakeholder engagement that allows them to understand what's happening in their community is really, really important. And it's particularly important if you put it on front of the meter, because that device impacts entire communities. Behind the meter may only impact a single premise. Maybe you could keep it away from residential communities or others who might be impacted. But front of the meter generally impacts larger numbers of customers and may impact an entire community. So all we are saying is we believe that individual case-by-case waivers should be heard, that the commission should make an informed decision rather than having this blanket, which may result in, that under 20 megawatt or 20 megawatt battery being right up against a residential property inadvertently, because we didn't look at each case. And there is, in fact, in Rule 7F, it provides for a streamlined process for waiver for front of the meter under 20 megawatts. So they are looking, Mr. Barkowski and our working group, we're looking to help expedite that process, but we don't feel that it is right to take away from the community the opportunity to understand and to express their concerns about devices that would be placed in or around their community. That's all our concern is.
So, I guess I don't really know what the term blanket exemption is. Is it defined anywhere here? So, if we were to strike blanket and just have an exemption request, then it gives us the discretion in how we want to define what that exemption is. So that my concern is actually the use of the term blanket, because I'm not sure what that means. And blanket could be an exemption from everything. So but if we were to strike, so Mr. Prokowski, if we were just to strike an exemption, so then really the focus of this language is on the fact that you can bundle several storage devices and then ask for an exemption. Pepco doesn't have an issue with that.
No, although I think that's already provided for I guess it's not express in the rest, but you're able to ask for exemptions already in the rest of the.
Right, but this is the bundling
The
piece of
multiple.
it. Right.
Yeah.
So then the focus of 11 is not so much on the blanket exemption, but on the fact that multiple projects can be bundled or devices can be bundled,
Sure.
and then ask for an exemption.
Sure.
And
As
then
long
you
as
wouldn't
that-
have a problem with that.
No, we just want it to come to you and you to decide on the facts of that particular request.
Right, and I think that was what I had the sense from you that was the intent of that provision,
Yeah.
was the bundling piece.
Unfortunately, blanket was my terminology that I introduced, and I agree that
Okay, so we just
Could be
strike
removed.
blanket and then we're fine.
Right.
Okay.
We'd be okay with that. Thank you.
Does that work for?
Yeah, and given we don't have the two companies here to actually explain why they needed this language, but I would just for the record like to say, I think we're going to really need these companies to have a robust market for energy storage in Maryland. Until we expect to see some utility proposed projects, but I think we also want to, again, have that competition of bringing these companies in to hopefully jumpstart and get our energy storage market working. So,
Yeah, Mr. Chairman, let me just say that I agree with getting rid of the word blanket, but I have to say that I'm personally very, very concerned about making it easy for people to shut down these projects. I'm very concerned about that, so I hope that as a commission we keep our eye on this process, because the last thing I want is for every community group in Maryland to exercise its own little veto, because that's currently what's happening, certainly in Montgomery County. Thank you.
Thank you, Chair Hoover. Mark Shebus for OPC. We didn't weigh in on this provision, I think, because we understood that it would, we read it implicitly that it would be multiple energy storages that were specifically identified in an application, rather than sort of a description of, well, we want an exemption for any energy storage device, whether we're planning it now or plan it in the future, that meets these particular criteria. We think that latter situation would be very problematic. So one, just thinking out loud and listening to this conversation, one additional edit that could be considered is the addition of provided that all of the energy storage devices are specifically identified and all applicable sections of this regulation are followed. That would perhaps address one of the concerns here.
So the concern I have is when you start to put limits on projects that might actually be good projects, then it sort of puts limits on our ability to weigh in. I mean, it may be, for example, a proposal where they're going to put one storage project this year and propose a second one the following year. I don't know that we necessarily want to tie our hands or tie the hands of the developers. They've got a really good project that comes in stages. I'd like to hear that. I'm concerned about. I understand your concern about gaming, and I'm really very mindful of the gaming issue. But I just don't want to tie our hands, especially where we're at the early stages of battery storage or storage in general, and I want to have as much flexibility as developers can have, recognizing that we're going to review all of this stuff, and if it looks like there's a problem, we're going to say no.
Thank you, Commissioner.
Anybody else? Okay. Mr. Dean.
For OPC's concern, I would point out that 07B requires a description of the specific energy storage devices and the state of their application. So that would also be applicable to H.
Okay.
We agree with that.
All right, so bringing this to a point, so essentially what we're doing is just eliminating the word blanket, correct?
Yes.
Okay.
And then we still have to consider the recommendation to add section I, and these are very similar comments from both 9 Energy and PowerFlex, and so I combined them into one sort of edit, highlighting the points that were brought up by 9 and adding the point that was brought up by PowerFlex. So I think both 9 and PowerFlex recommended an exclusion for devices less than 20 megawatt hours. The difference here is that 9 recommended proposed energy storage device exemptions from the stakeholder engagement PPRP review if they're located more than 100 feet from a residence, or if it's permitted within the applicable zoning district by an authority having zoning jurisdiction, whereas PowerFlex, since they do a lot of work installing energy storage, front-of-the-meter energy storage devices for commercial and industrial purposes, they added item C, which we can't get the whole thing on the screen, but
Yeah, no. So I guess starting with you, what's your opinion about these two changes?
my opinion is I empathize. However, I really would like to get some more experience before we start making changes like this. I do think there's going to be a time after we get some experience that we're going to have to come back to the commission and propose, some more targeted recommendations for exclusions. But as we start off this program, I don't think we really have anticipated, all those particular use cases where an exemption might apply.
And what about you? Any
We would
opinion?
oppose it as well. Again, first for the reason that Mr. Burkowski stated, we're very early in this process, but then going back to my stakeholder engagement, if you define these particular use cases, there could be use cases where it actually does really infringe upon a residential customer's land, and they should be able to, all this is whether or not they have to engage with stakeholders. It's not whether or not the storage should be built, right? And the stakeholder engagement may happen, and then they may build it irrespective, right? But at least the community, the people impacted have been able to understand what that storage device is going to be and express their concerns. And that's really what we are focused on, the ability to understand and express your concerns.
Yeah, thank you, Chair. OPC also agrees with Mr. Borkowski and the Exelon Joint Utilities. We think that at this stage, the Commission should rely on the exemption process. It may be that after a year or 2 years, if the Commission has granted, however many exemptions of a particular kind, and it's clear that it's highly unlikely that such an exemption would be problematic in the future, then the regulations could potentially be updated. But we don't think we're at the stage where it's appropriate to do that now.
Okay, and I think there's nobody here from 9DOT or PowerFlex, right? Okay,
Not that I know.
so anybody?
No, but again, you feel like we could address these situations in the exemption process. So, all right.
Okay, sounds good.
Yeah, because we talk about early stages, but this is something I think we need now, probably needed it yesterday to get some of these projects going on, and we have projects sitting in the PJM queue who we might be able to find maybe distribution system. So again, I think we just need to get out of the way.
Okay,
Projects.
So for the record, unless there are any other stakeholder comments, we're done with Regulation 7. The only change that we've made, since we did not accept the Section I addition, is to strike from Section H the term blanket.
That's correct.
Okay, so we're going to go on to Regulation 08, and I have to say there was a comment, and it was from the development community that was not captured in this document under 2A. They were recommending, I think it was either PowerFlex or 9DOT, I don't recall off the top of my head, but we kind of missed this. They were recommending a 0.25 mile radius in an urban area, indicating that it would be very burdensome, to contact affected communities in an urban area within a 1 mile radius. Now, when we proposed this, there's a lot of harmonization with the existing CPCN requirements. That's what we use as a starting point for some of these stakeholder engagement requirements, and so we lifted the 1 mile and the 3 mile for rural, the 1 mile for urban. in harmonization with the CPCN requirements. I do empathize again that 1 mile may be burdensome, but it is harmonized with CPCN. So I really would have liked to have heard some other feedback, because I'm sort of on the fence on this myself.
Is this, Mr. Chairman, kind of a question of like technology. I think some of the things we're talking about now in urban areas are like for, I guess, CT's combustion turbine. Isn't that kind of the technology you'd find for peaking units in an urban area? And, I know my condo over here on Water Street, there's one right across Gay Street, and that when that thing flips on, it is very, very loud, and I know people on that side of the building. So my point is, it's one of those technologies that maybe the CPCN current rules are for that type of technology, but given that a battery would have a lot of other advantages as far as being able to place and would be a little more compact. I don't know if we should just be a little more cognizant of those features and be at least open to the idea of a different standard for the storage technologies.
Well, I'm wondering if we can build a little flexibility into this. So the applicant comes to the commission, and perhaps within the application, so maybe the 1 mile radius is the standard, and then they can request a smaller radius that we can grant for good cause shown. I mean, so that we build, because it may be that 0.25 is also too wide a radius, and so rather than we can keep the 1 mile radius because it's consistent with the CPCN, but maybe build in a little bit of flexibility in the application, where they can ask for a smaller radius for notification. Does that make sense?
It makes sense to try to put flexibility. I'm just trying to figure out how to do it, because the
Well, it would-
application actually depends on the administrator of a program too, which in some cases, if it's a utility run program, they'd be making the application, to a utility. So
Okay.
I
So the application wouldn't necessarily come to us.
right, eventually the approval might have to come to you,
Right.
but the application itself might be problematic. I would maybe just suggest that the flexibility we need may already be identified in the exemption requirement.
That's what I was also wondering. Well, I guess the question is, to Ms. Harper's concern, that we need to make sure that stakeholders are engaged.
Yeah.
Can the exemption? I mean, it seems like it may be an all or nothing. So you either have to notify people within the 1 mile radius, or you don't.
Yeah.
And maybe there's a way that an exemption or a modification to the requirement of notification. I mean, I'm not sure if I'm still not sure who would be making the decision, though, because it sounds like, so for the PHI companies, would it be the companies would be making the decision about notification then?
Well, I'm just keying off your term application. I think that any front-of-the-meter storage device is going to have to go through stakeholder engagement, unless exempted, and then also go through a PPRP review, and eventually we'll get to the commission for approval. But some of the precursors in here are associated with the application, and not, it doesn't come directly to the commission like current CPCN case.
Right, but it seems like there's only, I mean, in terms of whether there needs to be stakeholder engagement. Seems like it's either an all or nothing.
Yeah,
So it's either within the 1 mile radius or not at all. And I'm just wondering if there's an avenue for a smaller radius, but the question is who makes the decision about the size of the radius.
yeah, I think that this
Because
could be
because
part.
and the concern I have is that sometimes when things are over inclusive, you essentially have no notification. I mean, if you're required, if you're living in a very densely urban area, and you're required to notify everybody within a mile, then there's really no effective notification. To Commissioner Richards' point, I mean, if it's very noisy within 100 feet, but no one hears it after that, then notifying somebody a mile away has no value. So you really want to have the kind of notification that is effective in terms of the specific project. And so so a mile may end up just being sort of so overly inclusive as to not being effective.
If we were to add flexibility, I would suggest it be added to Regulation 07 and just leave the 1 mile the way it is. So maybe we can retitle that to exemptions or modifications from regulations. And then everywhere there's an exemption, change exemptions or modifications in that particular.
Yeah, but the question is who's going to be making the determinations about?
You would in that.
Oh, we would.
Yeah,
Okay.
that's better than the application because the exemption request has to come.
Okay, so they would come to us.
Right.
And then we would allow for them. Okay, that makes sense.
Yeah. So if we can go back to Regulation 7 and the title of the regulations is a change to exemptions for modifications.
All right. And the good thing about that is that it also will give us an ability to kind of measure the effectiveness of the notification process. So we'll get some experience in that and make, because I think a 1 mile radius for a very small project
Yeah.
makes no sense.
So,
But
I would say waiver.
not to complicate things, but I guess I need an opinion from the lawyers in the group. I mean, I'm familiar with an exemption process. Does a modification process pass muster?
It'd be more properly considered to be a waiver of a regulation for good cause.
But it wouldn't be a waiver. It would be a modification. I mean, we're not.
Well, it'd be a partial waiver of the requirement.
Maybe we can substitute partial waiver. Exemptions or partial waivers from regulations.
If I-
Excuse me, what would a partial
Yeah, I
waiver?
guess
Yeah.
Yeah,
Well, for example, community energy, the community solar process
Uh-huh.
has a operational or commencing construction requirement within 3 years. And typically, when the 3-year time limit comes due and there's been difficulties in getting administrative permits, a applicant will request a
Okay.
partial waiver of that regulation and
okay.
establish a new deadline. And
Okay.
it's the wording of the regulation is the way it is right now. You get a partial waiver in extending a deadline.
Okay, I understand. I like the use of that word then. Thank you.
If I may, I also think that this can be part of the waiver. If they come to seek waiver of the mile requirement, in your determination, you can say, yes, you have waiver from the mile requirement, but instead you have to, have engagement with everyone within a half mile or something. I mean, it can come out of the same waiver process.
Well, why don't we just get rid of the term exemption and just put in waiver? I mean, isn't that what we're doing, is we're waiving?
That's a good idea.
I think that you need exemption from some of those because this is a blanket exemption in certain cases. For instance, let's go back to the CPCN requirement or exemption. Across the board, if you are a storage device that goes through a CPCN, you are in fact exempted from similar requirements within these regulations. So you don't have to come into the commission. It saves you the burden of someone asking you. That to me is an exemption, which is a little different from the waiver, where you have to seek waiver from the commission
Okay.
for a certain thing.
Okay, okay, but I think then you need to be, I think what you're going to need to do is be clear about what waiver is and how it's different from exemption. So I don't know that you can do, for each time you mention exemption, you have for exemption or waiver requests. I think you might have to actually have a separate provision for a waiver. A waiver can be requested for any of the requirements. So that do you see what I'm saying? Because otherwise I think it gets confusing then.
But I think you can do that easily in the wording here, because clearly these sections, a lot of them are waivers except for G, which is an exemption.
Okay,
And,
all right. I trust you.
And
Figure it out.
so if we would change it to exemptions and waivers
Okay.
from regulations and
Right. Right.
and then in A, section A, an exemption or waiver.
Right.
This is where the or is. And then, since we're only dealing with exemptions for the CPCN, B would be all waiver request. And I don't think we use exemption anywhere else. C would be all waiver request. D would be all waiver request. E would be all waiver request.
Yeah. Okay.
F would be waiver request. G would remain the same with exemption. And H would be waiver request.
Okay.
There's another exemption in E that you might want to change to waiver right at the
On
beginning.
this one.
Okay, and that actually makes that's
Yeah,
clear.
okay.
Because otherwise you have exemption and waiver
Yeah.
and it's not clear what one versus the okay, and then that makes sense.
G remains the same.
Okay.
H is waiver.
Yeah, yep, that passes second.
Yeah, and E and F have two places where exemption needs to be changed to waiver.
Okay.
Okay, so I think that'll clarify it.
All right.
I
All right.
That works.
appreciate the
No, I understand.
the lawyers in the room.
No, that's fine. Yeah,
Or-
that's fine.
We get
We're
caught up.
attuned to the meaning of
We
words
get
and.
Yeah,
we get
yeah.
caught up in words, and
Yeah,
so
it's a dumb
right.
Here,
Those
No, no,
lawyers.
we're fine.
brute force.
Okay.
Okay, I hope that's not the minutes.
We weren't listening.
Yeah.
Okay,
Right from the record.
Strike from the
Are we good
Oh.
with 7 then?
okay, so we're back to 8 now, and we've left item 2A alone, and then we had a section B recommended by 9DOT as an addition, where they wanted to bundle multiple projects in an area in the stakeholder engagement process. So they're basically saying that it'd be a lot more efficient for developers if they can if they've got a bunch of projects within 1 year or 1 calendar year of one another, within a 1 mile radius of one another, and the capacity is less than 20 megawatt hours, then just bundle them all and do all the stakeholder engagement at once, so they would, more efficiently, for both the communities and the developer, have these meetings and say, we're putting all these things together. I would like to hear other stakeholders on this, but I don't, if this was not raised in a work group, but I don't necessarily object to this
So,
as a work group leader.
any problem, concern?
Partly up here. We don't necessarily, sorry, we don't necessarily disagree again with bundling. I don't think that we would, I wouldn't put the criteria on it, and I would say that this has to happen through the waiver. I'm not sure that this should be added to the regulations itself. I think that this is handled through the waiver process. So I think we handled this already in H of the exemptions, 7H I think it was, where we took out blanket. I think that's what happens here. But what we wouldn't want to have happen is to bundle a bunch of projects that that didn't get some sort of scrutiny because they may be impacting, or some sort of stakeholder engagement, I'm sorry, because they may be impacting the community.
Yeah, it seems to me we've already sort of covered this, and if they want an exemption or a waiver, they can just ask for it. And I do worry, again, I'm worried about the gaming, and bundling a whole bunch of projects in an urban area, and then having no scrutiny, and no stakeholder engagement. I think that would be a bad idea.
My only, and I agree, we need to make sure that there are opportunities for public engagement, but I want to make sure also that this is not going to be duplicative of already what's required at this, the local and the county level. I mean, there are already zoning requirements, there are permitting, and a lot of those also include public engagement. So I recognize what we're trying to do. We don't want to cut the public out in any way. We want them involved. But what I'm hearing, and I wish they were here to talk for themselves, the companies, but when I read their documents, they really, this is a, could be very burdensome and make it very difficult for them to do business in our state. And I think we want to make sure that Maryland is a good place for these types of developments to come. And that we don't do anything that, something that the legislature has said is in the public interest, that we don't create barriers. So all we have to go on right now is the filed testimony of the developers, but I just think we should keep that in mind. I agree. Maybe we can do this at a waiver level. But again, I wonder if we could do something to recognize that this may be duplicative of what building anything already entails, and that is a public engagement process. And we just don't layer our own public engagement process on top of that. So,
And Your Honor, the Joint Exelon Utilities doesn't want duplication either. We just want the ability for stakeholders to engage. And if it were duplicative, we, as long as it happened, we
Well,
wouldn't.
that's what I'm wondering, if there's a way to recognize stakeholder engagement in another process, and have that be a demonstration of stakeholder engagement. Is there something in the regulation that recognizes that?
Not specifically, but I think that could be part of the good cause in a waiver request.
Okay. Do we want to specifically provide that? Such as, so the good cause, such as a stakeholder engagement required in a separate process. So then we avoid what Commissioner Richard is concerned about, and I am too, that we don't want to sort of create all of these barriers to deployment, and duplicative processes is certainly a barrier.
I would have to ask for maybe a legal opinion on that. I don't know if such as is appropriate in regulatory language. I'm not sure.
could we do like a section on, maybe a blanket automatic waiver, and provide under these certain circumstances.
We
Again,
could,
there
but
is
we-
another process that, again, ensures that we have a robust public engagement, but again, doesn't put a company that's trying to develop these projects through, multiple hoops, duplicative hoops.
Yeah, I feel like the way we've defined the waiver and exemption process can handle all these things, but if you want to signal, there are certain types, then we would need to have to craft another
Okay, well,
regulation.
if we're comfortable we're on the right track for having a good, solid waiver process, then I think my concerns are allayed, so.
And the joint Exxon Utilities agree with Mr. Barkowski that this could be done through the waiver process effectively.
Yeah, OPC also agrees. We didn't have any really serious concerns with this provision, except for the phrase single notice and meeting. Having a single meeting seems to make a lot of sense for projects that sort of share these commonalities. I think we're in a situation where company representatives, could potentially be flying in from far-flung places to have these sorts of meetings to meet with community members. But single notice is less less clear. I mean, section A3 of the current regulation, .08, requires the applicant to provide a description of the manner in which the applicant provided notice to the affected communities. That doesn't presuppose that there's a single notice, and I don't know if a single notice for multiple communities would really pass muster. So that single notice gives us much more pause than single meeting, but we also agree that this is something that could probably be handled through the exemption process.
Yeah, that just sort of weighs in favor of just striking this, that
Okay.
it's not necessarily.
Yeah, I think we'll
Okay, so we will
not adopt it, yeah.
not adopt
Right.
any of the changes
Right.
recommended in Regulation 8. We had no, unless there are any other stakeholder comments, I'm going to move to Regulation 9. We had no edit recommendations, and also for Regulation 10, we had no edit recommendations. So unless there were any stakeholder comments on either of these two sections, I recommend we go to Regulation 11. And there were a few comments raised by the both OPC and the Maryland Joint Exelon Utilities, and all these comments, and there's also a recommendation just solely made by Maryland Joint Exelon Utilities in C. So you got changes to A1 and 2 and C, recommending we change the mays to shall. And I have to admit, this was a last minute change. Originally was shall. However, I changed it to may to still state the intent of certain deadlines, but the commission, I would just offer, doesn't regulate itself, so I didn't want to put shall requirements in a regulation for the commission, because you don't regulate yourself.
Yeah, and I actually have, sort of consistent problems with telling us what we should be doing. So I think that is, I think that is just a problem. And I don't know that we can really do that in regulation or should be doing that. I think that would be bad practice.
So-
But that's just sort of, the lawyer in me sort of saying that. I mean, there's one thing to tell OPC what they have to do, but to tell us what we have to do is problematic.
All right, so I guess what I'd be looking for is anybody who thinks we should be told what to do. So. Okay.
Well, I will say that, sorry.
Actually, you have to, who you are and spell your name. Okay.
Sorry about that. Good morning, Chair Hoover and Commissioners. Crystal Barnett from BGE and on behalf of the Maryland Joint Exelon Utilities. So I don't want to frame it in terms of we're trying to tell you what to do. I think that this should more be framed in providing like a known and efficient schedule for developers of projects so that it provides fairness to them and they're able to better plan and manage their projects within a known framework. So, not necessarily in telling the commission what to do, but I think that a shall does allow for better planning. And I sort of look at it as like a case time schedule, if you will, so that they are able to manage their resources and plan their projects more efficiently. I
So,
think it ensures that projects continue to move along.
no, I understand. I'm just asking you, I mean, in our regulations, do we have a commission shall in the regulations? Because I think if we do, that's a problem.
I think I'm thinking more statutory, yes.
Yeah, that's
Um,
different if the General Assembly tells us what to do.
Yeah.
But it's not just awkward. I'm not sure that I mean, shall implies that there are things that happen as a result of not meeting the conditions, and I don't know that we can, that we, will we fine ourselves if we don't meet the conditions? I'm not sure it's awkward, but I
Well,
actually think
I think it's more than awkward. I mean, it's a principle that no legislature can bind a future legislature, and I don't think a current commission can bind a future commission. I mean, after all, if they disagree, 10 years from now, they could just very easily undo what we do. So I'm agreeing with you, Commissioner.
Yeah,
Sexton.
it's not appropriate.
So-
But I also think that it's probably not legal.
Well, the other issue I have is this is a timing situation. I think we understand that, us delaying things for no apparent reason is counterproductive to deployment of storage devices, which, we understand the state has a big interest in doing that, and I think we all think that that's a good idea. So I think, we'll have the motivation to not sit on things. The other thing I guess I'm a little concerned about is, there's a process in place for us to make decisions, and part of it involves staff, and so to the extent that we start imposing time requirements on us, you have to work back through the calendar to make sure that staff's got enough time to do whatever they got to do to tell us what we got to do on this. So I think I'm, for a variety of reasons, would rather leave all these things as may rather than shall. So,
Thank you, Sheriff. We fully understand the commission's concerns. I think we like shall as well, just because of the clarity it provides in terms of parties' expectations as to how these applications are going to be dealt with. But we're also obviously not looking for the commission to
Sure.
unduly tie its hands in any way. So,
Yeah.
yeah.
Okay, well, I think I don't get a sense from up here that anybody's excited about moving from that. But we understand the urgency of making these things happen, so we will use all deliberate speed. So.
Okay, so the commission did not accept any of the OPC or
Right.
Maryland Joint Utilities, just for the record, recommendations to change may to shall in this particular regulation. Mike Dean pointed out to me that we probably need
So actually, before we leave this, I mean, I'm not really understanding the point of even having language in here about what we may or may not do. I mean, we can keep it there because I guess it represents consensus language, but it's odd. I mean, you can have, in hearings and approvals, well, I mean, you can have hearings that kind of lay out the schedule for others. It's just an odd thing for us to be laying out what we may or may not do. That's just I don't, do we do this in other regulations? No. I'm troubled, and I can tell you as a lawyer, like, you don't put words in unless they have meaning, and so sort of hortatory, this we should make this happen when we get around to it. There's not a lot of value, and I worry about putting something in a regulation because it does raise the question about why is it there in the first place. And
Well, actually, just to push back a little bit on this, I mean, how much of this is designed to, because there's other agencies involved in this, power plant and the staff and things like that. I mean, how much of this is aimed at sort of organizing that part of the process as opposed to what we
Right.
do at the
and,
end of it?
and I'm fine with that. If we want to get the other agencies sort of doing things, we can sort of lay that out. But I'm just troubled by having language in here that talks about what we may do within 30 days. It's awkward, but I'm troubled by putting something in to the extent that somebody looks at this and raises the question, I wonder why the commission approved the language as is. Maybe they intended to.
I do think that, the motivation from the work group was to have some clarity in a process. So we tried to put process language. In fact, I'm working on other regulations right now related to distribution system planning, which also propose timelines for, that process. And I don't think that, I do think there are regulations that say the commission will do things. I know in our interconnection regulations, we are specific about filing like inverter settings in the administrative docket. So we want to make sure that there's some clarity about how that process works. I think if there's anything in here that could be pulled, because would be the timelines. Within 60 days, but I would still, for item 1, I would still want to indicate that this is in the administrative docket unless it's an evidentiary hearing, because I think it's providing that clarity to the process that people, stakeholders have advocated for.
And I certainly understand Commissioner Suchman's concern. I think they're very valid. But in this particular case, I think it's important that we lay out a process so that developers and people that we want to come into our state have a sense of how it's going to work and some certainty that we will try to follow our own timeline. So I would encourage us to keep it, particularly for this type of regulation.
Yeah, no, I'm just,
Maybe a halfway would be just like in item 1 to remove within 60 days of filing, but have the rest, to leave that at least, because, and then within, the
Just trying to understand
the
this-
specific timelines.
This all came from a work group, right?
Yes.
And so the work group included developers and the utilities that may also develop these projects. So I think for this particular type of a regulation where we're trying to incentivize, encourage, bring these developments to our state, I think some specificity might be helpful to them.
I'm okay with the language. I'm just sort of expressing my concern about having language that has that essentially doesn't do anything, be interpreted in a way that imposes some obligations on us. So I suppose, for the record, this section imposes no obligations on us to do anything. So.
Okay, no, I think, by keeping it as may as opposed to shall, it gives us enough flexibility.
Okay.
All right, so I think we're fine.
Okay, one other item in Regulation 11, Mike Dean pointed out to me that A2, we have to change exemption to exemption or waiver
Yeah,
request.
right.
And I think there's probably something in 10C that also talks about exemption reviews, where I think that really should be waiver reviews.
Okay, so, but I think that fits under that general
Yeah.
category of non-substantive changes, because,
Right.
again, if we're just making it consistent with something we already decided, I mean, because there may be other situations where, after we approve these things, where that comes up, so
Right.
I think you got.
So
the
we will
ability.
go through and make
Yeah.
sure that we
Right.
haven't missed
Yeah.
any of that.
Yep.
We'll make that as a
Yep.
non-substantive change.
Right.
Okay, so with that, I'll just open it up on item, Regulation 11, if there are any other comments. Okay, so the last regulation is the annual reporting regulation, which is Regulation 12, and there were no comments on that. So with that, I would say that we're done going through the regulations. It might be, I would recommend, Chair Hoover, that you might want to open it up to ask if there are any other comments that stakeholders would like to provide before we take a motion.
So, anyone else have anything that they need to bring to our attention before we take any action? All right, seeing no takers. All right.
I have one change to the motion, though, because of the fact that we changed Regulation 7's name.
Oh, okay. Well, actually, I'm just going to do the numbers. I'm not going to read.
Okay.
Yeah, so
Okay.
so don't worry about that. So. All right, with that, I move to publish the following new chapter and new regulations in accordance with today's proceeding in the Maryland Register for notice and comment, subject to any non-substantive changes necessary to conform to COMAR drafting regulations. And the first is add the following new chapter, COMAR 20.50.14, and then add the following new regulations, COMAR 20.50.14.01, 02, 03, 04, 05, 06, 07, 08, 09, 10, 11, and 12. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye. And with that, we're adjourned.